Hey guys, sorry I'm not with you today so we can do our normal little debrief thing together. If you are watching this video, that means each of our four judge panels went ahead and announced how they ruled in each of our four moot cases and why they ruled that way. With that, I just want to make sure that we have a little bit of direct instruction or discussion on the pairings or the cases that we did. Since you guys only did one set of those pairings, I want to make sure that you understand all four sets. Okay, so with that, the first case that we heard was McCoy versus Louisiana. And the people on that group were teamed with using the court case precedent of Gideon versus Wainwright. That's the required case that the College Board says you have to know for the exam. The key portions of the Constitution that were relevant in both of these cases were the Sixth Amendment right to an attorney in criminal cases, and then the 14th Amendment due process clause. If you remember, the 14th Amendment is what incorporates or allows the court to require state governments to provide the protections that are built into the Bill of Rights. So Gideon versus Wainwright was that precedent case, right? It is the one in which the court said that via the 14th Amendment, the right to an attorney in a criminal case must be granted regardless of the crime. The McCoy versus Louisiana case expanded the decision of Gideon versus Wainwright. It said that not only does a person have the right to an attorney during a criminal case, but that attorney needs to be representing the wishes of the defendant, right? In McCoy versus Louisiana, despite McCoy repeatedly telling his attorney that he was not guilty, he was not going to plead guilty even to a lesser crime, his attorney gave an opening statement that in essence said he was guilty and that he was accepting that guilty verdict. And so McCoy appealed, saying that his attorney, right, did not fulfill that, right? He had an attorney, but the attorney wasn't really defending his interests from his perspective because he explicitly stated that to him. Okay, a couple of other things that I noticed that came up when you guys were discussing these two pairings together was, when do you get an attorney? So this is actually determined. They actually look at your financial statements, right? Somebody can't just say, I don't want to pay for an attorney, right? If they say, I cannot afford an attorney, I need one to be appointed to me by the government. The government will look at that person's financial background and financial standing to determine if they do, in fact, have a need and would be incapable of providing their own defense. If that's the case, an attorney will be appointed to them and paid by the federal government. Federal or state government, depending on the level. Typically, this person is going to be from the public defender's office. Each state, each region has a public defender's office, which is a group of attorneys whose job it is to represent defendants that cannot afford attorneys. Sometimes if they are overworked, the government will hire out a private attorney to serve in that interest, but it still kind of works in the same basic way, in case you're interested in that. All right. If at any point you need to pause, feel free to do so. Okay, let me get my big old head out of your way. Okay, so looking at New Jersey versus TLO and Matt versus Ohio. Matt versus Ohio was the required precedent case that the College Board says you have to know. We heard the case of New Jersey versus TLO. In this case, they were both looking at the Fourth Amendment protection from unreasonable searches and seizures, kind of combined with privacy rights that aren't explicitly stated in the Constitution, but are often interpreted to be part of Fourth Amendment, 14th Amendment, 9th Amendment, tons of different amendments. Okay, in Mapp versus Ohio, right, Dolray Mapp, right, they searched her home without a warrant, right, they were supposed to be looking for a fugitive, they were looking at all kinds of different stuff, they found some evidence of obscene materials in which she was charged for, and she was found guilty. When she appealed this finally to the Supreme Court and said that this violated her Fourth Amendment because the police did not have probable cause, nor did they use that probable cause to get a search warrant to actually search her property, and therefore any evidence or materials that they found against her should not be used, or they should be excluded because they were found through improper means. They did not follow her basic due process rights. The court agreed with Mapp And so this incorporated those search and seizure protections into the states. It also established the exclusionary rule, or the idea that if at any point the government acquires information in a case through improper means or unconstitutional means, then any of that evidence has to be excluded from trial. It doesn't mean the person goes free. It just means whatever they got through an improper method cannot then be used. Okay, so we paired this with New Jersey versus TLO, which was a little bit of a different case, right? This wasn't the general public. We weren't searching her home. We were within a school building. And so the questions were here, does TLO get the same protections that MAP got for search and seizure? And the decision of the court was that no, right? Despite the fact that students don't lose their rights at the schoolhouse doors, Tinker versus Des Moines, right? The court also said in Tinker versus Des Moines that it is the school's job to uphold the purpose of the school building, which is education. It is the school's job to maintain the safety and security of the students within that building. So although you don't lose your constitutional rights when you walk through the schoolhouse, right, those rights can be limited more reasonably than they can in the real world, because we are protecting minors in a school setting and we are trying to ensure a safe educational environment. So New Jersey versus TLO specifies and then limits the MAP decision, right, to explain how this is different when we are talking about the school and not in general, right? In schools, there's a much lower bar. So in the real world, police have to have probable cause to then get a search warrant, right? Unless something is in plain sight or they are in the process of arresting somebody, right? Lots of exceptions that we did in our little round robin, right? In the New Jersey versus TLO case, right? Those are different because she is a student in the school building and they must protect that first. Therefore, the exclusionary rule was not relevant. The search and TLO's confession were able to be used in her suspension from school. Okay. All right. Dobbs versus Jackson Women's Health Organization, Roe versus Wade. Roe versus Wade used kind of a combination of the 4th, 9th, and the 14th Amendments, right to privacy to protect the right of a woman to choose to have an abortion. Okay. Dobbs versus Jackson was specifically challenging this specific policy. In the end, Dobbs versus Jackson reversed the decision of Roe, and not because it was saying whether or not abortion should be protected or not, right? It said that constitutionally, the right to an abortion or the right to privacy is not explicitly stated within the Constitution. And therefore, because it is not stated in the Constitution, the federal government doesn't have the right to kind of control that. And so basically what they did is they put this issue of abortion back to the states. And they said via the 10th Amendment state reserve power, if it doesn't give the power to the federal government, if it doesn't deny it to the state, then it is in fact a state power. And since they said that nowhere in the 4th, 9th, or 14th Amendment does it actually say the right to privacy or protect a woman's right to choose in an abortion case, it is a states' right issue, right? It's a federalism issue. And therefore, the states have the ability and the choice to make decisions in regard to that topic. Okay, so it did end up overturning Roe versus Wade, but not just because of the privacy component, but also because of the federalism component of that. All right, the final case that we looked at here was the New York Rifle and Pistol Association, and we used that or compared it to the required case of McDonald versus Chicago. We've talked about McDonald versus Chicago several times. It's also a federalism case in addition to a Second Amendment case. All right, so we're looking at Second Amendment right to bear arms. We're also looking at the 14th Amendment due process clause, which is what allows us to incorporate the Bill of Rights into the states. Okay, in McDonald versus Chicago, the issue was about keeping arms, the right to actually own a weapon, to have it. And they said that Chicago's ban on handguns violated that Second Amendment because a person does have the right to keep a weapon. And therefore, Second Amendment rights to keep arms was protected. Okay, that was 2010. Newark Rifle and Pistol Association, versus Bruin. I didn't put that on there, but you have it. Was a 2022 case. It expanded the protections of McDonald, right? It said that the bear part, right, the right to actually have the weapon on your person is also protected, right? This case was about whether or not. All right. So it was, sorry for the cutoff, the announcements keep coming. Okay, this was about whether or not somebody had the right to actually carry their weapon on them, not just the right to own that weapon. In the end, the courts did decide, right, we are going to expand those Second Amendment protections combined with the 14th Amendment. States have to respect it. It's not just about keeping arms, it is about keeping and bearing arms, and therefore people have the right to carry their firearm. Okay, so I hope that clears up those 4 cases for you. Please feel free to rewind, whatever, shoot me an email if you have a question, and I will see you guys on Tuesday.